Welcome back. Returning to our top story, the Albanese government is going to start releasing people from indefinite immigration detention. That's after a landmark High Court ruling. On Wednesday, judges declared it was unlawful to hold a person indefinitely if there was no realistic chance of them being able to be taken to another country. It ruled in favour of a stateless Rohingya man who faced lifetime detention, as no country would resettle him due to a child sex offence conviction. The government has conceded that some detainees currently in detention must be released, as it's not possible to deport them. The Immigration Minister, Andrew Giles, says any visas granted to those individuals will be subject to appropriate conditions. Joining me now for more on this, Shadow Home Affairs and Cybersecurity Minister James Paterson. Thanks for your time. The decision, first of all, did it take you by surprise?
What was perhaps surprising about it was that the Chief Justice issued his ruling after just 2 days of oral arguments, and the court didn't need to go away to consider it further. He said in his judgment there was a majority of justices who agreed. But either way, when there is a High Court challenge to the constitutionality of a very significant protection for the Australian community, governments must be prepared for the possibility that the judgment will go against them, and they must have a backup plan to deal with it if that happens, because you cannot out-legislate the High Court. And so it's really important that there is a plan B in place, and we've discovered this week from this government they had no plan B, and they are now scrambling to try and protect the community from potentially dangerous offenders being released.
So options on the table, seemingly from the Minister, he's saying this is the decision. There's already legal speculation that if we don't release them, we being the Australian government, we Australia, that there would be a big compensation bill to pay and that you'd be denying the High Court decision. So if that's the case, is the only option conditions on bail, which the Minister's talking about?
Well, the government should have by now already investigated all lawful alternatives to this ruling and be ready to introduce in the Senate, which is sitting right now, and in the House and the Senate, which is sitting next week, legislation to put in place the most robust legal protections for the community that they think will withstand any future High Court challenges. That might involve continuing detention orders like we have in high-risk terrorism offenders. It might involve extended supervision orders or control orders, which also exist in the terrorism framework. Those are some of the options available to government. But really, anything that they can do to protect the community is necessary. And I just don't have confidence in the government being on top of this, because yesterday in the Senate, the Agriculture Minister, Murray Watt, answering a question on behalf of the Home Affairs Minister, said only the applicant in this case, just one person, would be released, and none of the other 92 affected people would be released until the court handed down its reasoning, which could be weeks or months away.
Okay.
And now the Immigration Minister has admitted today that's wrong, and they could be released imminently.
Perhaps the legal advice has changed. We did ask to speak to the Immigration Minister. On those protections you outlined, I mean, they're already there, aren't we? All those various orders. Wouldn't they just be applied on a case-by-case basis? If someone... What are you talking about that would be new? Is it new legislation for a particular type of risk cohort you can outline?
The ones I'm talking about only relate to high-risk terrorist offenders. It's a framework for terrorism offences
that's
only.
in place now.
And some of these 92 people may have been convicted of terrorism offences, we don't know. But almost certainly they would have been convicted of other offences, like this applicant who was convicted of a child sex offence against a 10-year-old boy. There will be domestic violence cases in there. There may be murder cases in there. There will be other violent offences, drug trafficking in there, or people who violated the character provisions of the Migration Act for other reasons. I'll get to character
in a moment, but for all those other elements, I mean, we have laws in place, and if anyone, it doesn't matter if it's someone that was in immigration detention, if anyone in the community is released on that, we have protections and restrictions on bail, don't we?
There's a really important difference, which is an Australian citizen has an absolute right to be in this country. A guest or a visitor from overseas does not have that absolute right. And we would never normally grant a visa to someone if they were convicted of a serious crime. And we would deport them if they were convicted of a serious crime.
Right, but my point is around when those people are released, we are conscious and there are provisions in place and orders and so on to protect the community. We have them in place already. Are you saying new ones would be needed, new legislation within this cohort?
I'm saying normally this problem would be dealt with by deporting these people or putting them in detention. Given that we can't do that, every other lawful option needs to be investigated, and I don't have confidence the government's done that.
But if there's an Australian citizen that was convicted on the same charges as this Rohingya man, they would be released, they'd have to be,
yes,
and there'd be various elements in place around where they could go, what job they could get to protect the community?
Not necessarily, Tom. It would depend on the offence that they committed. Maybe if it's a child sex offence, they'd have arrangements put in place, and certainly if it was a terrorism offence, there would be. But for some of those other crimes, there wouldn't be.
Right. But obviously, this person there would be. You're saying
not necessarily. No, I have no confidence that that's the case based on the government's handling of this so far. They've said they will attach conditions to his visa, but we don't know what those details are. We don't even know what the other 92 people are convicted of, or the even larger cohort of 340 people that the Solicitor General referred to in the High Court who might also have to be released. Who are they? Where are they from? What offences have they committed? Will they have to be released to? When will they have to be released? These are all questions the government hasn't answered. Where is the Immigration Minister today? Where is the Home Affairs Minister today? Why have they not fronted up to the public? Why have they not done a press conference?
So if you think about our overall system right now, I get you have different rights as an Australian citizen versus someone else, but theoretically they still pose the same level of risk to the Australian community. If you commit this sort of offence, this is the risk you pose. Would that suggest our law is not fit right now to deal with risks from even Australian citizens? Because why can't we just apply, if someone's at risk for this offence, here's your restriction on your bail? Why can't that apply to these people the same as it would to Australian citizens?
The obvious difference, Tom, is that you can't deport an Australian citizen and you can't detain them for not having the right visa because they don't need a visa to visit our country. Migrants, guests in this country are in a different category. Every country in the world recognises that it is a privilege to visit your country, that it's reasonable to attach conditions to that. If those conditions are not met, it's reasonable to deport them.
Perhaps I was not asking clearly. I mean, so if there's an Australian citizen that's committed the same offence as this Rohingya man, the Australian community knows they're allowed to stay in Australia and get released, but expects there will be protections placed on them. So surely the same ones can be placed on this person, or if it's another offence that happens to an Australian person, the same for someone being released.
I understand the point you're making, Tom, but I'm saying that visitors and guests in this country have a higher bar to meet because they don't have a right to be in this country. And so we are not willing to accept the same level of risk in the community posed by a non-citizen than we are from an Australian citizen because they're different categories of people and they have different rights.
Right. But that implies there's sort of a level of risk we accept with an Australian, and we're saying, oh, well, let's raise the bar. Isn't that a bit of they're still people, right?
But, Tom, a visitor and a guest in our country should only be permitted to be here if they're good character. That is the reason why we have the character provisions in the Migration Act. That is why we say you cannot come to this country unless you meet those provisions. And if you break those provisions, we will deport you. I think 99% of Australians would support that proposition. It's not controversial at all.
So you're talking about a higher level of restrictions on someone in this situation, whatever the offence might be. In fact, I believe we've got the bells ringing. Are we getting an indication? All right. I think you're required to the Senate.
Thanks, Tom. Next time.
Thank you.
Cheers.
All right. Well, 18,000 Victoria Police officers